Welcome to Sakshi TV Special Immigration Short Talk Show with attorney Mr. Parvathaneni. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Mr. Kaveti, on Wednesdays with Prashanti Reddy in English, on Thursdays with Parvathaneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on the show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can definitely contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, you can definitely log on to his firm, which is www.spvllaw.firm.com site. It provides wealth of free information and online tools in the hands of immigrant community that you don't have to be a lawyer to understand. They explain laws in very simple terms, so you can definitely check out their website. Without any further delay, let's welcome Parvathaneni Garu to our show. Parvathaneni Garu, welcome back, Andy. How are you?
Hello, Shivani, and hello, everybody at watching Sakshi TV today. Thank you very much for joining in. I'm pretty good. Thank you.
Parvathaneni Garu, today we decided to talk about the new rule changes to the H1B visas coming in the year of 2024. But before we get on to this topic, do we have any latest immigration updates that we have to cover before we get on to the topic?
Sure. A couple of things have happened in the last few days, and one of the main things being last week of October, it was announced that the proposals to modernize the H1B program, some very drastic changes might be coming through in 2024. And as a first step, the draft proposal got published in the Federal Registrar last month in October. So what that means is we can expect some big changes going forwards in the H1B program. And the draft proposal is what are the current proposals. And by the time the finalized regulations take place, a lot of things could change. But what we know for sure is some things are changing, and at least for a start, we have the proposal out there. And this draft proposal is available for public viewing and commenting. And a lot of things. It's a very big, very large document. So it looks like a lot of things are coming down the pipeline. That's number one. And number two, recently USCIS has also announced that the wait time for the Indian nationals, for the green cards, it could be a very, very long time. And they basically said that this current, the next couple of months, they have enough they have enough 485 numbers, enough 485 pending applications for Indian nationals. And what that means is they might not be even taking new 485s for this current fiscal year, and probably also for the next fiscal year. We don't know yet. But what we know for sure is we might not be seeing any progress in the visa visa bulletin dates for Indians for EB2 and EB3 category. So that came off as a bad news. But again, what that boils down to is there is a lot of demand in EB2 and EB3 category for Indian nationals, and people who have not yet applied for 485s because the date is not current probably might not be able to apply for 485s this entire fiscal year, 2024 fiscal year. And the reason for that is they already have enough pending 485s that are more than what are available out there. So that was one news that came out. And another final thing is the H1B lottery. So the H1B, the second lottery, the deadline to apply was October 31st. So that deadline passed. And whichever company got a selection, they were able to apply until October 31st. But based on what we are seeing in our law firm and what we are seeing with talking to other attorneys, a lot of people did not file even after getting selected in the second lottery. So our guess is a lot of there are still open slots, and there is a possibility that we might have a third lottery. It is too early because the filing period just ended about 10 days back on October 31st. And what USCIS is going to do now is they're going to receipt all those petitions that were filed, and they will redo their data analysis. And if there are any free slots, they typically would announce a third lottery. At this point of time, I think it is a possibility, and USCIS has not confirmed either way as of today. So in short, that's what's going on in the employment-based immigration in US.
Yes. So, Mr. Parvathaneni, is it true that there will be a lot of changes for the new H1B lottery? And also, what kind of changes are we expecting? And also, is this going to stop the multiple registration issues that has been happening in the US from since couple of months?
Right. So, I mean, if you look at the data that USCIS published for the most recent H1B lottery and also the year prior to that, what they clearly proved is that there is a lot of fraud happening. And the reason they say a lot of fraud happening is because the same beneficiary, the same H1B beneficiary, multiple filings were done by multiple companies, and the numbers were looking so weird that definitely there was some kind of a collusion between various parties. And they have access to a lot of data, and they have very good data analysis tools, so they can find out commonalities. So what they're trying to figure out is, if the employee got multiple job offers, getting a multiple job offer, it's legal, it's nothing wrong about it. But what's wrong is when there is no real bona fide job offer, multiple companies colluding together and trying to increase somebody's chances in the lottery by registering for the same person from all these different entities. That kind of a collusion is illegal. And USCIS has data analysis tools. So it is very simple. They pull out the data, they look at company A, company B. They see if the owners are related, the owners are living in the same city, the owners have any things that will tie them down together. They've done business in the past. Maybe they have a lot of overlapping registrations, a lot of things. So when they see a lot of factors that make them feel that the companies are related, they question them. And things like having a common, the companies being in the common city, the companies being owned by common relatives, having the same tax person, same attorney for filing. So all these tend to indicate that these companies might have known each other. And that is what USCIS is pointing out in these notices that we are seeing. They're showing all these facts and saying so many things are in common. That means we feel that your company and your company have worked together, colluded to increase your chances in the lottery. And they realized this is a big problem. And I think what is happening is everybody understands that this is a major problem and this problem has to be fixed, because this is an industry where which is very critical to US and also very critical to the careers of many employees who are working in this industry. So USCIS has realized the problem, and they said that they will recommend cases that have been fraudulent for prosecution. And at the same time, they're also acting towards making changes to the current registration process. And so a draft has been published, and in the draft, what they're trying to do is, instead of letting an employee come through these multiple companies and let them participate multiple times in the lottery, what they have said is they will use the passport. So even if an employee gets multiple job offers, that is legal. So an employee can get multiple job offers, that is legal. But when they're doing the lottery, they're going to use only the passport number, the unique passport number in the lottery. So what that means is, if an employee has 10 different job offers, last year he was put 10 times into the lottery, so his chances increased. Going forwards, what USCIS wants to do is use their passport number. So the passport number will be entered only once. So it is a unique registration. So the duplicate multiple registration, that entire problem is eliminated, because even if the employee has multiple job offers, he's not getting into the lottery multiple times. He's getting into the lottery only one time based on his passport number. And what that means is, the whole advantage of getting these multiple job offers from these multiple companies, that is eliminated. And that would completely eliminate this multiple registration collusion issue that has caused so much of problem in the last 2 years. And again, right now, a proposal has been published, and it is not a regulation yet. But what we think is, before the lottery next year, the lottery is expected in March. Before the lottery, we are expecting some kind of an interim rule that will make it a rule. And more than likely, we should be able to not have the same multiple registration issue going into the next year's lottery.
Yes. And also, are there any finalized new H1B changes that are going to take place from the fiscal year of 2024?
So The rule making is a big process because we're dealing with the government agencies. They have to follow certain guidelines, and if they don't follow those guidelines and they make some arbitrary rules, tomorrow people, somebody who's impacted, they can sue the government and make the government strike down those regulations, those rule changes. So what that means is the government, in this case, Department of Homeland Security, they have to follow the rule making process, and they have to take each thing step by step. And the very first step is publishing the proposals, the proposed rule changes out for the public. And the common public, the public should have an opportunity to take a look at the proposals and give their comments. So that is what is happening right now. So USCIS has all these changes that they want to make. They publish the draft. And now what is happening is the public, the common people, they are taking a look at these draft proposals. And right now, it is a 60-day commenting period. So for the next 60 days after this proposal was published, people can go and comment. They can say, "Hey, the rule looks very good," or they can say the rule looks bad because of these reasons. Maybe you should have done it so and so way. So various things. So different people give different comments. And what USCIS does is they have to wait until their 60-day time period is up. The 60-day time period is up in December. So December 22nd, 2023, the 60-day period is up. And that is when USCIS, DHS, they will go through all the comments of the public, and maybe they'll find some comments very useful. And based on that, maybe they'll make some other tweaks. After all of that is done, they have to publish the finalized version, the final rules in the Federal Registrar. And only when the final rules are published in the Federal Registrar and a timeline is given by them, from that time on is when these rules will take into effect. And what that means is, at this point of time, the rules are, the key idea behind this proposal, modernizing the H1B program, the idea is very good. And there is a big need to modernize this H1B program. But at the same time, they cannot rush and do something in a hurry and cause a mess. So they're going through the process. And what that normally means, based on how they work, is that the changes will not happen right away, very quickly. But I think at some point of time in 2024, we can expect these changes to go into effect. And the final version of the rules could be a lot different from the current proposed version. Could be different. And that is why we have this commenting period where USCIS, DHS gets a chance to review and make the finalized version. So what that means is in 2024, we can probably expect some kind of a final rule. But right now, the rule is not finalized yet, but the proposal is out there and actively being considered, and people are commenting during the commenting period.
Yes. And also, Parvathaneni Garu, we're hearing that people with non-computers background, especially ones with MBAs, are going to be having some tough times in the year of 2024 for their H1Bs. Is it true, or is it just fake news circulating?
So one of the major changes that they have proposed, and that has been published in the proposals, is that they're going to revisit the concept of specialty occupation. And what specialty occupation means is, so for some job to be eligible for a H1B, that job should require a specific degree in a specific specialty. So that rule, it's going to be tweaked a little bit in the new rules. So in the new rules, what they are saying is, to do a job, somebody needs a degree or a related degree. So for example, a software developer, you can require various degrees. For example, computer science, computer engineering, information technology, software engineering. So in the new rule, what they're saying is, yes, that is okay. You can require different degrees, but that degree should be a narrow degree that is relevant for the job. And it cannot be a generic degree. So for example, for a software developer job, you can have computer science, computer engineering, information technology, information systems. That is fine. They're okay with it. But the new rule says that they cannot have a generic degree. For example, a regular engineering degree, for example, civil engineering or mechanical engineering degree. It is not a related degree for software developer job. Or for example, an MBA. MBA is a generic business degree. It is not focusing on a specific specialty. So somebody with an MBA degree cannot probably apply for a marketing manager job, or for example, for a software developer job, unless they prove that there is more specialty in that degree. So again, they're more than likely, I think they're complicating the specialty occupation definition, and a lot of people are already seeing problem with the current proposal for specialty occupation. What it means is, if the rule goes in the current fashion, we might be seeing more RFEs and definitely seeing a lot of tough time for generic degrees like MBA, because MBA is a business degree, a generic degree. It is not in a specific specialty. So anything that is a generic degree, or where the relationship between the degree and the job is not too close, like civil engineering degree for for a software developer job. So those kind of degrees might face a lot more challenge going into the future. And right now, since the final rule is not published yet, we don't know the impact. But if the current rule, as they're proposing, goes into effect, definitely, I think we will see an increase in the RFEs for specialty occupation, and probably a lot of denials for people with MBA degrees for the H1B jobs. And that is a possibility. The only good thing is, right now it is under comment period. So a lot of people will give their input during this commenting period. And hopefully USCIS streamlines the rule, but not in such a way that it doesn't reflect the actual realities of the industry. So we'll have to wait and watch. But things could get a little bit challenging for some generic degrees if the rule gets passed.
Yes. And also, Mr. Parvathaneni, we kind of always talk about these USCIS site visits. You think that now that the new rules are coming in, the site visits will be more strict than how they were?
So in the current regulations, anytime an H1B gets filed, the FDNS officers, the fraud detection officers, they typically can go and do a site visit. And this is called an administrative site visit. So it happens all the time. However, in the current rules, it is completely a voluntary participation. So a company which gets an FDNS officer, a USCIS officer visiting their office, today, in the current rules, the employer has a right. They have a right to refuse participation because it is voluntary, and they can refuse to participate, or they can participate, or they can participate partially. And that is the current rule. However, what is going to happen in the new rules, at least in the proposal, USCIS wants to make it mandatory. So it is going to make it mandatory for the officers for the employers to participate in the site visit. So what that means is, the burden becomes a lot higher for the employers, for the petitioners, to participate in these visits. Sometimes when they have an administrative site visit, which more than likely happens randomly, sometimes even if the company is not targeted, just because they participated in the H1B program, randomly they're targeted. And when they are targeted, when there is a site visit, the officer will ask them a lot of questions, ask them for a lot of data, and so on. Sometimes those visits are burdensome because the employer is busy with their work. They have to stop everything and answer these site visit questions. Some are like simple site visits, but sometimes they ask for a lot of information. And going forwards, what that means is, even if it is burdensome, the employers will not have a choice. They will have to participate. It's a mandatory participation. If not, the H1B can get revoked. So it is going to put more onus, more burden on the employers. And again, it is not finalized rule, but definitely we know that something is going to change, because the current FDNS program probably is not as effective as we want it to be. And what kind of rules will be in the final version, we have to wait and watch. But if the rules goes into effect, it will not be a voluntary participation anymore. It is going to be a mandatory participation, with some serious impact if the company does not participate.
Yes. And also, Mr. Parvathaneni, what is a gap, and also in the new rules, how will it change? Do you think it's going to change? And can you explain in detail to the viewers?
Sure. So in the new proposals, some rules are really good. I mean, really, I think looking at the industry needs and trying to make some changes. And this is one of those rules. So whenever there is an F1 person who is working in the country on OPT status, so every time there is a student, once they graduate, they get something called OPT. So OPT is optional practical training. And using their OPT work authorization, they can work for various employers And typically, these employers like their work and sponsor for their H1B. What happens is the company has applied for their H1B, and during this process, sometimes this work authorization expires. And under certain circumstances, the current rule, it lets these people, these students who have their employment authorization expire, they can still continue to work. But in the current rules, they can only work until September 30th while their H1B is in process. So this new rule, which is a very good rule, what it says is, it says that these employees can actually continue to work until 6 months after September 30th, till April 1st, as long as their H1B is pending. So this gives a lot more flexibility to students whose OPT is expiring, and also to the companies, because these companies have hired these employees. And while they're waiting for their H1B that is in process, the employees can continue to work. So this new rule will allow these OPT employees to work on cap gap until April 1st, which is 6 months more than what they're currently allowed to work. And this would be a very beneficial rule for a lot of F1 students whose OPT is expiring.
Yes. And also, Mr. Parvathaneni, can you explain a little about the H1B amendments and when are they required to be done?
So the H1B amendment. So what happens is a company files for H1B petition, and at the time of filing the H1B petition, they tell USCIS the location that somebody is working from, the job that somebody is going to work, the job duties and salary and so on. And once they get an approval, normally what happens is things sometimes change. Sometimes the employer, they get another project. They have to assign them to a different city. Maybe their initial work location is in Dallas, and all of a sudden the employer needs to assign them to, say, New York. So there is a change in the employment conditions. So USCIS, their rule is, if an employee is working for a company and there is some kind of a material change in the employment conditions, maybe they got their work location changed, or maybe their job duties, their occupation changed, or some kind of a material change, USCIS requires the companies to notify USCIS. They have to tell USCIS that something is changing and these are the new changes, and they have to file an appropriate LCA and an appropriate H1B petition and file it with USCIS. This process is called an amendment. So they're amending their initial approval. So this process is very important because an amendment has to be done before the new changes can take into effect. So the company has to file an amendment, and only after the amendment, they can transfer the employee to a new location. So these rules are very important. And right now, based on a court case in 2000, I think probably 2015, a Simeo case, people are required to file an amendment. So USCIS is going to more than likely codify this in the new rules and make it mandatory. And what that means is all the companies, all the employers that are filing H1B petitions, they have to be aware that if there ever is a material change, they have a burden to notify USCIS immediately. And the way they do that is through filing an H1B amendment petition.
Yes. I think with that, we have concluded our topics, but if there are any more updates, we can definitely get on our next episode. Thank you again, Parvathaneni Garu, for tuning in. It's always lovely to have you on our show. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you.